Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. California. We're going to talk about Road v. Bonta again. Why is that? Well, you smell that? That's that smell of freedom. You guys have a little bit more of it today than you did a couple of days ago, and hopefully you've been taking advantage of it, buying as much ammunition as you possibly can before, of course, the Ninth Circuit sticks their nose into it. Now, California, in typical California fashion, immediately pissed themselves and immediately demanded a stay so that they could get their appellate paperwork in place. Now, in the case of both Miller v. Bonta, which dealt with California's assault weapons bans, and Duncan v. Bonta, which dealt with the high-capacity magazine ban, we saw Judge Benitez actually go ahead and issue a stay for that exact reason. This time, yeah, he really has no interest in doing that, and he is telling California exactly where to put it. You don't believe me? Let me read the order to you. So today, let's spend a few minutes and let's talk about when Judge Benitez starts trolling your Attorney General. Okay, here's what we're talking about. This video yesterday went through the ruling and order of Judge Benitez striking down California's law, which required mandatory background checks if you just wanted to buy a box of ammunition. Struck down on 3 grounds. It was struck down on Second Amendment grounds. It was also struck down under the Dormant Commerce Clause, and was struck down under federal supremacy. The other thing that we did not get into in that video, and I'm actually going to read the whole order because it really kind of gives you a flavor of where Judge Benitez is coming from. Because I got to tell you that if he really was not a fantastic judge, what I would say he should be is a political speechwriter, because he can tell people to go F themselves in such the polite and eloquent way. Because this 2-page order denying the stay, because California is like, oh, we need a stay, we need to get our appellate paperwork in place, we're just going to come unraveled at the seams, Judge, if you actually enjoin this law. And of course that was filed literally within moments of the ink drying on the final order. But Judge Benitez has in fact denied that stay, and done so in a rather eloquent fashion. Let me show you what I'm talking about. Defendant requests a stay of this court's decision and permanent injunction pending appeal, or in the alternative, a 10-day administrative stay. The defendant says that if the decision is allowed to stay in effect, it would irrevocably alter the status quo by enjoining enforcement of laws that have been in effect for over 4 years, allowing prohibited California residents to acquire ammunition during the appeal and jeopardizing public safety. Because without this California law, apparently that state believes that that's the only way you're ever going to keep prohibited people from possessing ammunition, like any law is actually going to do it. The judge also goes on to state, a stay is not a matter of right, even if irreparable injury might otherwise result. It is instead an exercise of judicial discretion, and the propriety of its issue is dependent upon the circumstances of the particular case. In exercising its discretion, the court is to be guided by 4 legal principles or factors. 1. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2. Whether the applicant will be irreparably injured absent the stay. 3. Whether the issuance of the stay will substantially injure the other parties interested in the proceeding. And 4. Where the public interest lies. The first 2 factors are the most critical. The defendant here has not shown a strong likelihood of success on the merits, i.e. the first factor, or the likelihood of irreparable injury, the second factor. And that really is the end of the inquiry, and the judge could have ended the order there, but no, why do that when you still have an extra half page and you can stick it to that California Attorney General? Judge Benitez then goes on to state, as to the first factor, the defendant's case on the merits is weak, failing both the interest balancing test and the history and tradition test. As to the second factor, the defendant argues irreparable injury will occur without a stay because prohibited California residents will be able to acquire ammunition during the appeal. Simply showing some possibility of irreparable injury fails to satisfy the second factor. The possibility standard is too lenient. While there is a possibility that prohibited California residents will be able to acquire ammunition without a stay, there continues to exist criminal laws against the possession of ammunition by prohibited persons under both state and federal law. This court's decision in no way affects those laws, and the defendant is free to continue to enforce the same. Consequently, the second factor does not weigh in favor of a stay. The third and fourth factors weigh heavily against granting a stay, as the enjoined laws are infringing on the constitutional rights of citizens. And then finally, the court wraps it up this way. This court has given the state plenty of opportunity and time to provide analogs or other evidence to demonstrate the validity of its ammunition background check laws. The decision simply requires a return to the status quo ante litem as it existed prior to the effective dates of Senate Bill 1235 and Proposition 63. Having considered the relevant factors, and for many of the same reasons articulated in this court's order denying a stay of the preliminary injunction order, the request for a stay pending appeal and administrative stay is denied. Now, all of this is really good news. All of this is very encouraging. I will encourage all of you to withhold total excitement yet, because the Ninth Circuit is hanging right over the top of it, and we absolutely know what a circus that whole thing is and what's likely to occur there. So this is not the last we are going to talk about this case. Listen, we'll go ahead and link up the order down below so that you can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is also down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.